Hey there, this is Jody Clock, and welcome to my podcast, I Woke Up Dead, Now What? In our conversations, we'll talk about real issues that everyday people face should they wake up dead without a life after death plan in place. Join me as we explore the how-tos on preparing for you or your loved one's passing without breaking the bank. And let's not forget about those pets too. Now, don't you fall asleep. Hello, everyone, and welcome to my podcast, I Woke Up Dead, Now What? This is Jody Clock, and I am here with an amazing individual who has a lot of exciting stuff to share with us. Her name is Kathleen Flammia. She is an elder law attorney who specializes in estate planning, Medicaid planning, probate, and trust administration. She leads quite the team in her office, but more importantly, her key staff are her 3 dogs, who are the senior VP mascot, the vibe manager and head of all things amazing, and the manager of Doodle Relations. Welcome, Kathleen.
Thank you, Jody.
So it's been a long time since we visited. I think the last time I saw you, we were in Florida and we spent some time on a cruise ship with some mutual friends.
That's right. We had a great weekend.
Yeah, we did. And that was pre-COVID. So it's been a while.
Yes.
So for our listeners, what I'd really like to do today is really dial down. You have so many expertises, but I want to really focus on probate. And, I'd like for you to explain why someone needs more than just a will. And the reason I want you to do that is I don't know how many times I sit down or my husband sits down when he's waiting on a family and they'll say, yeah, mom had a will. Or when we're pre-planning, oh, we have a will. It's all covered. And I'm like, yeah, well, you might need to rethink that. So with that little statement, I'm going to pass it off to you.
Sure. So a lot of people think that they have taken the time to design and write a will and properly execute it, that they're all set. They're good to go, so to speak, and they can die and everything will be taken care of. But that's not really true. A will is written instructions to the probate court that tells the court who you want your personal representative to be. Up north, they call that the executor. In Florida, we call it the personal representative, which is the person who hires the lawyer to administer the will through probate. So the assets that go through a will are those things that are in your name and your name alone when you die, meaning there's no joint owner and there's no beneficiary.
I need to chime in and interrupt you. Everyone, if you hear those little barks, that is one of her her dogs there. That is the doodle of all things amazing. I think that one is. Anyhow, didn't want to take your mojo away, but
no, that's
there
okay.
He is.
That's okay. So yeah, the things that go through probate, your name alone. So typically when one half of a married couple dies, there is no probate because things are generally jointly titled, or if, say, the husband has a retirement account or a life insurance policy, there's a beneficiary name, typically the surviving spouse. And those assets go by operation of law directly to the named beneficiary. So it's only if you die with something in your name and your name alone does it go through probate. And when I say it goes through probate, I mean you have to file the will with the court. The judge has to accept the will and issue letters of administration, which is the legal document that allows your personal representative or your executor to act for you over those assets that are just in your name and your name alone when you die.
Well, you said a mouthful there, and there was a lot of instructions. So is it best to do it through an attorney, or is probate something that someone can do on their own?
So in Florida, you need an attorney unless you are the sole beneficiary of the estate. Then you can do it on your own. But otherwise, you do need an attorney. And there are some legal steps that you have to do when you probate a will that include filing a notice to creditors so that anyone that the person who died, the decedent, owed money to, has an opportunity to file a valid, timely claim. And there's an order of priority in Florida, at least, on who gets paid first out of the estate. So the attorney gets paid first, the funeral bills get paid first, the last 3 months of medical bills, and then it goes all the way down to claim 8, which are unclaimed creditors. So all these entities and people are going to get paid in a probate before the beneficiaries of the will see any money.
So you mentioned something that I'm very familiar with. As you know, I keep mentioning that we have a funeral home, and it is not uncommon for someone to front the money, when it maybe a son or a daughter, and then file that against the estate. And so basically what you said, that goes to the top of the list and they are reimbursed. Is that correct?
Yes.
So what about credit cards? I mean, if there's not enough money there, is it just too bad, too sad?
Yes, it is. They're an unsecured creditor. And if there isn't enough money, that goes through probate. And if the surviving spouse isn't on that credit card as an owner, then they're not liable for their deceased spouse's credit card bill.
So let me ask the question. Would someone have to sell that individual's, the deceased home to pay off the creditors? How does that work?
Not in Florida. In Florida, thanks to our Florida Constitution, Article 10, Section 4, creditors cannot force, unsecured creditors cannot force the home to be sold. So if you have a mortgage on the property, obviously somebody has to pay that mortgage, but a credit card, a medical bill, those unsecured creditors can't make the home be sold.
So if I hear you correctly, what you're saying is it's state by state.
Yes.
They might have different parameters, but on the big picture, most places don't make you sell your home for that reason.
I can't say most places. I can definitely say Florida.
Okay. So one more reason to consult an attorney for that. So tell me, what happens if someone does not have a trust? At minimum, what should they do?
Well, everybody's situation financially is different. And I don't think that everybody in the entire world needs a trust, but there are some important factors to consider as to whether you should have one. For instance, if you have property outside the state of Florida and you have property in Florida, you're going to have a property in that other state when you die if you don't deed that real estate into your Florida trust. So that would be a very useful tool to use a trust for. If you have LLC interests, or if you have money that you want to leave to your heirs in a protected fashion, like in another subtrust, then using a trust will avoid probate, and it can also hold subtrust for your adult children's assets for a number of different reasons.
So I was always under the perception that the primary reason to elect to go to probate, number one, have a trust, is because it slides through probate without airing all of your assets to the general public. Is that correct?
Yes. The only thing in Florida that gets filed when you have a trust is a one-page notice of trust that says your name, the name of your trust, the date of your death, and it's signed by your successor trustee, and they put their address. That's the only thing that gets filed, as opposed to a will. The entire will gets filed. It's a matter of public record. Anybody can go down and read it. So having a trust certainly keeps things private, because even after you die, the only people entitled to a copy of the trust are qualified beneficiaries, people that would inherit from you in the trust. If you disinherited someone, they are not even entitled to a copy of the trust.
Wow. That is a really strong reason to have a trust, and why those two work together so well. So what happens, let's just say, what are the consequences for not filing with probate?
You might not be able to get someone's assets if they left assets in their name alone when they died, because the legal mechanism to get it out of the decedent's name is going through the probate process. So there could be money left on the table, so to speak. You or your family might be entitled to money that no one is claiming.
So is that where and I might be saying it wrong, is that where like the escheats come in? I think that I remember in my insurance background, if there was not a beneficiary after so many years it went to the state, is that what happens? What happens to that money?
If no one claims the money, it goes to unclaimed funds after a certain number of years. And then you can fill out the paperwork and typically, honestly, have to go through probate to get a personal representative appointed to get the funds from unclaimed funds.
All right. So that's quite a hassle. So yes. Once again, another reason. So I always see all the family feuds that happen, and there might be a will that someone did in their earlier years, and they did not update it down the road. And so then the feud happens, and then they think because dad wrote down something on a napkin that this is his last will and testament. So the two questions that I have is, can a will be something that someone writes in a spiral notebook and gives to someone? I mean, is that acceptable with the court? And then the second one is, can a will be modified?
So when you sign a will, it does have to be executed with certain formalities. It has to be witnessed by two people and notarized. And then in Florida, we have an additional requirement of something called a self-proving affidavit, where the testator signs their name again, it's witnessed by two people again and notarized. And that makes it self-proving so that after the person dies, the will can easily be admitted to the probate court without any further evidentiary hearings or affidavits or anything like that. Can a will be changed while you're alive and mentally competent? You can, of course, make a change to your will. Not a problem.
Wow. You hear those horror stories and you never know what to believe. So are there any situations where a family does not have to file in probate?
If things are jointly titled or there's designated beneficiaries on the decedent's assets, then there's no need for a probate. As I said, typically with the married couple, upon the death of the first spouse, there's not a probate needed.
So I'm going back in my archives a long time ago when my son was a senior in high school, and the graduation drill, kids go out, they party, and sometimes some kids don't make it home that night. And there was one gentleman who was a dear friend of my son's who unfortunately died in a car accident. And he was considered an adult because he was 18 years old. And he had about $2,000 in his checking account. If I remember correctly, that had to be probated. And I guess I was always under the assumption, an adult is 21. So in that quagmire, when kids are going to college and something happens, what should parents do?
Well, we always tell parents, especially like right now, we're approaching graduation and kids are graduating high school, going to college, graduating from college. And we always tell parents that once someone turns 18, even though they'll always be your child, they're an adult. You have no legal right to find out anything about their medical information. They would have to sign a HIPAA release to do that. They should list you as a power of attorney agent so you could access that bank account, at least while the child's alive. I always tell people that have an account just in their name to list a beneficiary on it to avoid probate. There's no reason why it should go through probate.
Well, I think that's very insightful. And I really wish there was some class out there that young parents could learn, or at different phases of, your children, or I'm going to say parenting, because many of my friends, they didn't have a plan if something happened to them and who would take care of their children, let alone as they became adults. And actually that creates a lot of problems and a lot of headaches and probably a lot of family feuds. So If I hear you correctly, it's really at every age, the minute you become an adult, plan for the worst, hope for the best, or cover your assets, if you will.
Exactly.
Wow. We processed a lot of information here. What is the one thing that you would like our listeners to take away from this conversation today?
Well, Jody, I'm a planner. So to me, it's important for everyone over the age of 18 to have certain documents, basic estate planning documents in place. I can't tell you how many cases we've handled where, the 20-something-year-old got in a car accident or a motorcycle accident, and their parent had no legal authority to act over them, to close down their apartment, to collect their last paycheck, to access their bank account, to make a medical decision. So it is really important that even once they turn 18, they have these basic legal documents in place to allow someone to act for them. Because if you don't, then you're looking at getting a guardianship. And we want to avoid that because we don't unnecessarily want the government involved in our lives. We don't want to be court supervised over decision-making abilities of our loved ones. People just do this as a family. They need to have the legal documents in place to handle it.
And could you be kind enough to remind us again of what the names of those two documents are, those important documents?
Right. The durable power of attorney is the document that allows your agent to handle your finances. The healthcare surrogate, someone can make your medical decisions for you. The HIPAA release, Health Insurance Portability and Accountability Act, that allows someone to access your medical information so they can make an informed medical decision for you.
So does one person have to be in charge of all three of those, or could you have three separate people?
Absolutely. Three separate people, whoever you want.
Awesome. This is good stuff. Good stuff. All right. So before we sign off, if someone wanted to reach you, where could they find you?
Our phone number here in Winter Park, Florida is 407-478-8700.
All right. Thank you. I will put that on our website, jodyclock.com, and I will have every avenue that you can find Kathleen. And I want to thank you for sharing a little bit of your day with me. And more importantly, I'm glad, Kathleen, you didn't wake up dead today.
Thanks, Jody. Take care.
Bye.
Bye.
Hey, if you're hearing this message, you've listened to the entire episode. And for that, I want to thank you. And I am so glad you didn't wake up dead today. Please jump over to jodyclock.com and download your free copy of my family care plan. This guide will help those you leave behind should you wake up dead. I promise. Be sure to order my book, It's Complicated, based on a true story. Send me an email about topics you'd like to hear in future episodes. Until next time, thank you for not falling asleep.